name's David Smith. I'm a partner here at Anthony Gold Solicitors. And what I'm talking about today is the Immigration Act 2014 and its impact in the private rented sector. I'm very pleased to have been joined by Gareth Fowler from KeySafe, who are, I'll let him do the introduction better, but certainly one of the most substantial tenant referencing organisations for both landlords and agents in the UK. And Gareth and I spoke quite early about the impacts of the right to rent checks and how it would work for the sector, and he's done quite a lot of work on that, and I'll let him explain that in a bit. So without further ado, I want to crack straight into the legislation and look at it. So the Immigration Act 2014 is, of course, a big flagship bill from the Conservative Party primarily, introduced this year, that covers a range of different immigration matters, but also includes a new system to create a right to rent in the private rental sector. In part, what the government is, of course, seeking to do is to, as far as possible, marginalise people who are not lawfully in the United Kingdom and make their general movement around the UK system as complicated and as difficult as possible, and to put up as many barriers across a wide range of things as possible, so that they don't have to secure the border, basically. Other people secure the internal border, so the external border doesn't have to be secured. That's the objective. How well that works, I will not comment on. It's up to you. You may have your own view. I have a view. I'm not going to tell you what it is. So let's start with a quick outline of what's going on here. As I've already indicated, the Immigration Act 2014 creates something new called a right to rent within private rented sector accommodation. That right to rent can either be permanent or it can be time limited, and I'll explain more about that later. All private sector landlords or their letting agents, one of the two, must take reasonable steps to examine whether or not the person they are renting to in every case has a right to rent, and they must not rent where it does not exist. In some cases, they will also have to carry out follow-up checks on those people roughly every 12 months. So you have to check initially and then recheck and continue to do so. If you let to somebody or you rent property to someone who does not have a right to rent, then you can be fined. It's that simple. So if you either don't check, or you check very carelessly, or you check and they don't have a right to rent and you do it anyway, those are all situations in which you can be fined. So let's talk about some of the key documents. At the moment, things are rather in flux at the moment because there is a code of practice which is required by statute, and it's in section 32 of the Act. The government must produce a code of practice, and they have produced one. But it's still described as a draft code of practice, and given this starts to come into force from the 1st of December, some might say they're leaving it a little late. It's also still being updated. So the first code of practice I saw was produced and dated September 2014. There's now a fresh one dated October 2014, which appeared at the beginning of this month. And these notes and this talk is based on the October 2014 version. I in no way guarantee the October 2014 version will be the final version that will actually come into force on December 1st, and I can no way guarantee that will continue to be the final version into next year. So you need to be aware that it might change, and there might be further small changes. There are some other notable documents that are worth considering. Obviously, there's the Act itself. Clearly, I started out by reading the Immigration Act, but that's because that's my job, that's what I do. I don't recommend it as a read. It wasn't much fun. It actually doesn't make a great deal of sense. It was a couple of hours of my life that I could have done something else with. Obviously, I can't think of anything else I would rather do, but it was a bit of a nightmare. So sections 20 to 37 of the Immigration Act are the core stuff that actually sets out this power in general terms. There is a charmingly named Immigration Act 2014 Commencement Number 3 Transitional and Saving Provisions Order that brings into force a range of matters, but also gets what's called the evaluation going in specific trial areas. So it has brought parts of the Immigration Act into force for the private rental sector from the 1st of December in specific areas of the country. And I will talk about that later. There will no doubt be further orders as this is rolled out across the country as a whole. There are then a series of supporting documents which you can find at this web link that I've given you in my slides, and they'll be in the handouts as well. So there is a draft Landlord's Code of Practice, which I've already referred to, which is a general description of how it works, which is the statutorily required one, and also how it will be enforced and what the fine levels are and how they will be calculated. That's required, so the government was always required to produce that code of practice. They've produced a second code of practice that they were not required to produce, but they've done it anyway, on how to avoid unlawful discrimination when carrying out the checks, which I will talk about in a bit. There is a third document that you'll find there called a Right to Rent information leaflet, which is aimed at landlords. It is a single sheet of A4 with large type in pretty colours. It is not, in fact, very useful, I'm afraid, and contains no substantial information, but it could adorn an agent's office wall if you've got nothing else to put up. You probably do. Currently, there is no document targeted directly at tenants. There is a chunk of the code of practice which is directly written to appeal to tenants and phrased as targeted at tenants, but there is no specific tenant-targeted document from the government at all. The government makes reference to its guide to tenants, which you can now find in their website, which talks about tenants' rights and landlords' responsibilities, but it doesn't mention the right to rent at the current time in any way, shape or form. It talks about repairing obligations in Section 21 and all of that stuff, but doesn't actually mention rights to rent. So there is currently no programme in place to notify tenants that landlords are going to start asking them for identity documents. So it might come as a surprise to many tenants. I can see that going badly. The other new document that's appeared is the so-called Right to Rent tool. I'm going to refrain from somewhat crass and off-colour jokes involving the word tool. So there is a Right to Rent tool, which you can access from the previous link, but it's here. It's basically what is in web parlance is called a wizard. So it's a series of questions and a walkthrough that helps landlords carry out checks. So it gives them guidance on how to do it, and gives them guidance on how to contact the Home Office's landlord check service. Basically, it's a computerized checklist. What can I say? It's very, very early. It's described as an alpha test, so it's not even what you would more commonly call a beta test. So normally in software terms, an alpha test is something no one would ever see. A beta test is something that you might let some people see. The government has taken a different view and is releasing alpha tests to the world. You can go and play with it. Obviously, that means that any advice it gives you might well be wrong, and that would be unfortunate for you. It seems to me that a substantial objective of this tool is actually to cut down on random phone calls to the Home Office's landlord advice service saying, what the hell am I supposed to do? Because the Home Office appears to be having some difficulty setting that up. Whether that will work or not is yet to be found out, and I suspect the Home Office is going to be unsurprised or unpleasantly surprised by just how many phone calls they're going to get. So what I want to talk about now most specifically is the actual right to rent, which is the core stuff. So there are essentially two types of right to rent. There is a permanent right to rent, and there is a time-limited right to rent. So a permanent right to rent is for a UK or EEA or Swiss national. That is, people who are entitled to enter and reside within the United Kingdom on an unlimited basis at any time. So obviously if you're a UK national, you can reside here, clearly. EEA means the European Union plus Norway. Nationals of those countries are allowed to enter freely into the United Kingdom and reside here on an unlimited basis, and so are Swiss nationals on the basis of a treaty we have with Switzerland. So all of those people have a permanent right to rent by default within the United Kingdom. Then there are another category of people who are also covered by the permanent, which is any person who has a permanent leave to remain or reside in this country. Now there are a number of ways that can be acquired, but it'll be endorsed on their entry documents. So someone who has applied for permanent residency within the United Kingdom and been granted it. There is also a time-limited right to rent, which is fairly obviously, really, people whose right to remain and reside in the United Kingdom is limited in their extent of time. So they might have a right to reside in the United Kingdom for 12 months. That might be someone who's here on an educational visa, for example, someone who's here for medical treatment, or someone who's here for an extended visit. So most people who are not EEA or Swiss nationals will normally enter the country on a time-limited entry visa, unless they have particular ability to obtain a permanent right. There is also the rather confusing name permission to rent, which is not a right to rent, it's a permission, which is a special status granted by the Home Secretary. It's not quite clear how the Secretary of State from the Home Office is going to grant that. I suspect it's probably intended to be targeted at asylum seekers. So people here on asylum basis will probably be granted a permission to rent. Right, what's covered? It would be far too simple to say every situation is covered, because it's not. So it only deals with adults, people over 18. You are not concerned in any way, shape or form with people under 18. If someone moves into a property when they are under 18 and their tenancy begins or their occupation right begins, you are not required to carry out any checks once they become over 18. So provided you are reasonably satisfied they are under 18, note you can't just assume they're under 18 because they tell you they are, you do have to consider the point. But if you are reasonably satisfied that someone is under 18, you are not obliged to check them. You're not obliged to recheck them when they pass their age of 18. But you're going to have to find some mechanism or think about how you're going to prove that they are in fact under 18, which of course probably means in practice you will to some extent be carrying out a check on them anyway. It covers all forms of residential occupancy. So though it talks about rights to rent, this is not just about tenancies. It covers lodgers, it covers licensees of all varieties, it covers anybody who you give permission to reside in the property. So you cannot cheat the system by saying, I'm going to rent to you because I know you have a right to rent, and nudge, nudge, wink, wink, I don't mind if your mate stays there as well because I don't want to check him out. You can't do that. So any situation where you know that someone's residing in the property, then they are covered by the system and they must be checked out. So you can't close your eyes. This does not cover holiday lets. So properties where it's there for the purposes of a holiday, obviously that's an evidential test in each case. Properties which are not the main home of the occupiers, again, it's an evidential test in each case. You'll have to consider where their bills go. And it's the kind of the same test you would apply is to consider whether or not the property fell under the Housing Act 1988, perhaps. It doesn't cover long leases, which in this case has been defined as any lease of over 7 years. Although it's worth noting that if there is a break clause that allows you to terminate the tenancy in less than 7 years, then it is not a lease of over 7 years. So you can't, for example, cheat the system by giving tenants an 8-year lease with a break clause after 18 months. That's not a lease of over 7 years. It would still be covered by the right to rent. It doesn't cover mobile homes, and it doesn't cover student accommodation, and that includes student halls of residence, any situation where the university is placing the student or nominating the student into property, even in the private sector. So one way around this, actually, is for a landlord to set up private sector student accommodation and then contract with the university for the university to nominate specific students to occupy that accommodation. That is exempt from the right to rent. And that is actually happening more often inside the student sector. More and more landlords are contracting directly with universities in respect to their accommodation. The checking itself. The duty is to check for the right prior to entering into a rental agreement. However, you can hold that back to a check just before occupation if you can't reasonably check it before entering into the rental agreement. So if the person is abroad, is unable to give you their documents, but enters into a tenancy agreement, and then they arrive in the UK and you check the documents prior to occupation, that will be acceptable. Now the ultimate problem with that, of course, which the Home Office has kind of missed, is if I enter into a tenancy agreement with you because you're abroad and you come to the UK and I check the documents to discover you don't have the right to rent, I'm not actually allowed to refuse you access to my property because we entered into a contract for it. And if I do refuse you access to the property, you can sue me for damages. So in practice, I don't think that's a particularly helpful distinction for the Home Office to draw, unless you're going to put a clause into your contract to cover you, which I will get to later on. If it's a time-limited right, the duty arises to check again before the end of the time limit. So you don't get to the end of the time limit and have a grace period to sort your life out. You have to sort out the recheck, or the follow-up check as it's called, before the end of the time-limited right. So people will be sitting there thinking, oh, it's every 12 months. Actually, it's not. It's a little bit less than 12 months because the time-limited right normally is for 12 months. You're going to have to check before 12 months to renew your time-limited right. If someone remains in a property and their time-limited right has expired, you are under an obligation to report them to the Home Office. And I'll talk about that a little bit later on. You don't actually have to evict people, I hasten to add. So someone who has been rented a property for 2 years and has a time-limited right to occupy say for 12 months, if that then finishes, you don't have to evict them, you simply have to report them to the Home Office. Now, of course, that means in practice the Home Office will then turn up, arrest them, and remove them from your property, and your landlord will be somewhat knocked off because they will have thought they're getting a 2-year tenancy and they won't have got a 2-year tenancy. So there is a practicality issue there that's a bit of an issue. But it is a problem. There is a circuit there that doesn't work very well. The obligation can be passed on by agreement. So a landlord can pass on the obligation to carry out right to rent checks to his letting agent, but only by specific written agreement. If it's not crystal, then it remains with the landlord. And if you're a tenant who's been given permission to sublet, you can agree with your superior landlord that the checking of the subtenants will actually be passed back up the chain to the superior landlord. Why any superior landlord would agree to that, I do not know. But again, it's something you can do, but it must again be very clearly done in writing. I don't recommend anyone doing that, I hasten to add. Right, documents. This is where it all gets serious and complicated. So the right to rent is primarily tested by documentary evidence. So you're not required to carry out really hardcore checking or interviews or anything stressful like that. It's a documentary-based check. There are multiple lists of documents. The government's called them A, B, and C. I've renamed them to make them more sensible. There are 2 lists that relate to a permanent right to rent, which I've called the safe list and the semi-safe list. But I said they're my names. The correct name are the A list and the B list, if that's what you prefer. Mine are just easier to remember for me. And there is a time-limited list in respect of the time-limited right. So there are 3 lists of documents: a safe list, a semi-safe list, and a time-limited list. And you have to check documents from those to establish the right to rent. So the safe list first. This is the easiest list. Any one document off the safe list will establish someone's right to rent on a permanent basis. Now, it's worth noting the safe list is quite good in the sense that you can use expired documents unless I've specified otherwise. So all of these documents, unless it says current only afterwards, you can use a current or expired document. So the first one is any UK passport, current or expired, or a UK and colonies passport showing a right of abode. Bear in mind that not everyone who has a British passport automatically has a right to reside in the United Kingdom. There are categories of people, for example, Hong Kong citizens, who were Hong Kong citizens prior to it going back to China, were given British passports, but they were not given a right to abode in the United Kingdom. Many citizens of Gibraltar have UK passports, but they do not necessarily have a right to reside on the mainland. Okay, so there's a difference between a UK and colonies passport and a UK passport. Anyone who has a full UK passport which issued after the 1st of January 1983, which states that they are a British citizen, has a full right to reside here, and they will have a permanent right to rent. If their passport was issued prior to the 1st of January 1983, or it's a UK and colonies passport, then they must have an endorsement that explicitly states they have a right to reside in the United Kingdom. If they have a passport issued after the 1st of January 1983 that's a full British passport, and it doesn't say British citizen, it will have an endorsement expressing what their right to reside here is. So either none at all, or time limited, or full. Okay, it might change as well. So the endorsements will go up and down, potentially. Any EEA or Swiss passport or national identity card, so for example France, which has an endorsed national identity card scheme, will also be an acceptable, again, current or expired document will do. That will establish a permanent right to rent. So if you can prove that you are a full citizen of any EEA, Swiss or UK nationality, you get a right to rent, because you can't prevent that. In the United Kingdom, you can't stop people coming in from Europe unless you're Nigel Farage. Any UK, Swiss or EEA registration certificate showing a permanent residence. Now, they're increasingly deprecated. The UK doesn't issue them anymore. We have various forms of exciting biometrics, and most other countries don't do it either. But any full certificate showing permanent residence issued by a UK, Swiss or EEA country. The UK new biometric indefinite leave to remain document, but not an expired one, a current one, establishes a permanent right to rent. So that's the full snazzy biometric one. It's got a chip in it and fingerprints and all kinds of cool stuff. It actually looks very like a passport, actually. But it's not a passport, it just looks like one. Okay? Any passport or travel document endorsed to show exemption from immigration control. To the rest of us, that's a diplomatic passport. Okay. Again, current or expired as it happens. Any immigration status document with a photo endorsed with leave to remain, but only a current one. So an immigration status document that's been provided that has a photo on it, that would be what you would call a visa. So a UK visa, okay, with a photo endorsed with leave to remain. And then obviously any certificate of registration or naturalisation as a British citizen, kind of obviously. If we've naturalised you as a British citizen, then you are a citizen and you can stay here. That's the whole point. Okay, those are all safe. Any one of those documents, many of which can be expired, will be satisfactory. Obviously, if you can't present any of those documents, things are a bit of a problem for you. So then we get to what I call the semi-safe list. So if you're using a document with the semi-safe list, you must have two of these documents presented together. Okay, so you can't use a single document off the semi-safe list, you must have two. As a rule, these must all be current. You can't use expired documents. So the semi-safe list is harder work. So the easy one, a full birth or adoption certificate, but it must show the name of at least one parent. Okay. Any letter from the last 3 months which confirms the holder's name, either from a UK government department or local authority, but it must be signed by a named official giving their appointment, so you can't fake it, hopefully. Or if you do fake it, there's an individual we can go and ask if you actually did it. Or any document signed by a UK passport holder confirming the holder's name. So frankly, you can get anyone to sign it, provided they're a UK passport holder, but it must give that UK passport holder's full name, address, and passport number. So we'll find them if they did it they did it and they shouldn't have done. Or a letter from an employer giving the employer's full name and address, confirming the individual's name and their employment status. Okay, so those are acceptable. A letter from the UK police confirming that ID documents have been stolen in the last 3 months with a crime reference number. You must have a crime reference number to be satisfied. So if you report ID documents stolen to the police, it's not enough merely to report. You must obtain a crime reference number and obtain a letter confirming that those documents are stolen, citing the crime reference number, if that's what you wish to rely on for the semi-safe list. Any evidence of previous or current service in HM Armed Forces, so a discharge certificate, a letter signed by the Ministry of Defence, or of course a current HM Forces ID card would be acceptable, or an expired HM Forces ID card would all be acceptable as a form of ID. Any HM Prison Service letter, this one might put you off a little bit for other reasons, but any letter from HM Prison Service confirming the individual was released from prison in the last 6 months, or a letter from the probation service confirming that this person is still under their care, so released on licence or on probation. You may not consider those people suitable tenants for other reasons. Any letter from a UK further or higher education establishment confirming the person is undergoing a course of further or higher education. A full UK driving licence, by which I mean both part and counterpart. You must have both. And I will say this again later, but for most of these documents, both sides of the document must be copied. I'm not just interested in half of it. A current UK firearm or shotgun certificate, again, may put you off the tenant for other reasons. Any document from the disclosure or barring service, so that's what used to be called the Criminal Record Service, so a disclosure document for the purpose of being a teacher or solicitor or something like that, saying that you don't have any criminal record. As long as it's produced within the last 3 months. And any benefit paperwork from HMRC or a local authority benefits office or the Department of Employment or a job centre produced within the last 3 months. I suspect if you're on the semi-safe list, you may find yourself using this one a fair old bit. Okay, so if you're using the semi-safe list, any 2 of these documents will establish a permanent right to rent. So just to recap, so we're all crystal, it's quite a long list. Any 1 document from this list, the safe list, any 2 documents together from the semi-safe list. Okay. I'd say my suspicion with UK nationals is that an awful lot of people will find themselves working off the semi-safe list, quite a lot, certainly from the kind of the people who present to this office. I find that the semi-safe list effectively is what we find ourselves doing a lot of ID from in certain categories of person. There's a time-limited list as well, so any one document from this list will establish a time-limited right to rent only. Okay, not a permanent right to rent, a time-limited right to rent. So any valid passport at all with a time-limited right to stay endorsement that obviously hasn't expired. I hasten to add, obviously, if it's expired, then they obviously don't have a right to rent. They shouldn't be here. Any UK biometric immigration document that has not passed its time limit that's endorsed with a right to reside here. Any current residence card for non-EEA nationals who have a derivative right to reside in the EEA. So if, for example, I'm a non-European EEA national, but I have a child who is an EEA national who is not 18, I have a derivative right to reside in the in the UK and the European Union generally, because obviously that child needs care and you can't remove them from the European Union, and you therefore can't remove me either because I'm there to care for them. So it's a derivative right. Yeah. So current residence cards for non-EEA nationals who have derivative rights. That card will make clear that they have a derivative right to remain. Any immigration status document with a photo endorsed with a time-limited leave to remain, but only a current one, again, that's a visa to you and me. And then a yes from the so-called Landlord's Checking Service, which is the new Home Office service, which I'm going to talk about in a minute. But the Landlord's Checking Service is only for people who are telling you that they have a current application or appeal ongoing before the Home Office. So the Landlord's Checking Service is there for you to check that. Okay, so a yes from the LCS. That's acronymed already. Okay. Further key points to note with documents: you must see the originals. You must see them in the presence of the person who holds them, or by live video link. Obviously, live video link means they have to move. They can't hold up a picture of somebody else in front of them. And the whole point about that is you're supposed to look at the photo on the document and compare it with the face in front of you to see that they are the same person. You're supposed to check them for consistency. Obviously, the photo for impersonation purposes, so sudden large bushy beards aren't acceptable. You must check the document hasn't been obviously tampered with. We're not expecting you to become professionals in document tampering, but clearly if the back's been cut out and there's lots of sellotape on it, you should probably be a little bit concerned. You must keep copies of the documents. You're absolutely required to copy them. For passports, you don't have to copy the whole thing, but you must copy any page which shows the expiry date, the nationality, and the date of birth. So that's the key page near the end of most passports these days. And the page that shows the person's right to be in this country, so the visa page, basically. Okay? Every other document, you must copy all of it. And in that case, I mean usually both sides. Particularly with biometric IDs, you are absolutely required to copy both sides. So even the boring back bits should be copied. It must be copied in a non-alterable form, so a straight photocopy is fine, but you can do it by electronic scan, provided it can't be altered. But a straight PDF scan of an image is perfectly acceptable. And you must maintain copies of those documents for 1 year after the right to occupy ends, so 1 year after the end of their tenancy. Now, the other point to note with documents is the Landlord's Checking Service is in no way there to confirm documents. So the objective of the Landlord's Checking Service, lots of people have got this idea, and the Home Office sort of casually suggested quite early on that the idea was you could call up the Landlord's Checking Service and they would confirm whether documents you were looking at were valid or not. That's not what it does. The Landlord's Checking Service is not there to check documents for you. It is simply there to confirm whether or not someone who's purporting to have an appeal ongoing before the Home Office does in fact have an appeal ongoing before the Home Office. Okay? So if they come to you and say, I don't have any documents, but that's because I'm an asylum seeker and the Home Office is considering my case, then the Landlord's Checking Service is for you to check that information. Okay? It doesn't do anything else really beyond that. So you can't use the Landlord's Checking Service to say, I've been given a passport which looks dodged to me. and it's got a visa that might have been produced on a laser printer half an hour ago, can you just confirm whether this visa is a real one or not? That's not what it does. Okay, you can't do that. For permanent, obviously anyone who satisfies the permanent list using the safe or semi-safe list, you can relax, job done, no worries. They can rent for as long as they want, they're permanent. Anyone who has a time-limited satisfaction, so who satisfies the time-limited list, and that may well be people on the permanent list who can't produce good enough permanent stuff, they must be followed up, either within 12 months, or if their right to remain is longer than 12 months, at the end of that right to remain, or if their document has an expiry date on it, that date. So it's the longest of 12 months, the end of the right to remain, or the expiry of the document you used to establish the time-limited right. So it's not automatically 12 months. The 12 months will be the shortest time. But you must do it before that time period elapses. So it's a bit irritating in terms of running a procedural system. You can't turn around and say every 12 months. It'll vary. Some people will be longer. But in all cases, it will always actually be slightly less than 12 months for a lot of people. So to do it, to carry out a follow-up check, it's very simple. You must ask for further documents off any of the three lists. If the person then produces documents off the safe or semi-safe list, then they get upgraded to permanent status. They have a permanent right to rent. Your problems are resolved. Or they can produce documents off the time-limited list and establish a further time-limited right to rent for another 12 months or longer, depending on the documents produced. And you will then have to recheck again. Okay? If they haven't produced any documents on request, so if you ask them for documents and you get no response, or they fail to establish the sufficient right, either time-limited or permanent, then you must report them to the Home Office in writing and before the check time period runs out. So if you have to do a check within 12 months, you have to have done the check, failed the check, and reported to the Home Office before the 12 months is up. Otherwise, you're liable for a penalty. Okay? If you are making a report to the Home Office, it must be done in writing. It can be done by email, with the full name of the occupier, the property address, the landlord and agent details, the occupancy start date, and copies of the documents used to establish the original right to rent, and copies of any failed documents for a follow-up. Okay, so they want to know who it is, where they are, who you are, and what documents they've produced, and then presumably somebody will turn up and start removing people and doing whatever they do. There is no obligation on you to evict people. Although that said, you may take a personal view that you may wish to evict those people if you have an ability to do so. Okay, you're not obligated to keep them there either, so you don't have to hang around, have to leave the people in place for the Home Office to turn up and cart them off. You can simply start eviction process. It's up to you. Right, current and future situation. It's important I tell you this is not a pilot or an evaluation. The government is very clear, it's not a pilot or an evaluation. It is a phased introduction. They're very clear about this. They will be evaluating the phased introduction, but it's a phased introduction across the country. Article 6 of the commencement order sets out that it's only applicable in current areas from December 1st, and those areas are properties located in the local authorities of Birmingham City Council, Dudley, Sandwell, Walsall and Wolverhampton. Okay, so it's the Midlands. Most of you will not need to worry too much right now. Okay, it only applies to tenancies that begin after, or occupations that begin after the 1st of December 2014. So if people move in now, you don't have to suddenly go on the 1st of December, my God, I better start checking. Okay, so it's only for stuff that commences after that date. In principle, the government has said they're going to evaluate the phased introduction, even though it's not an evaluation, they're going to evaluate it anyway next spring, and then there's going to be a further phased introduction. Of course, what they really mean is it all depends who wins the election. As many things do at this time of year, it all depends who wins the election. Both Labour Party and Liberal Democrats have said that they are opposed to this and won't do it. Now, whether that statement turns out to be true after they've got your vote is another matter. Obviously, not all political parties have a great record with keeping election promises. I'm not going to mention the Liberal Democrats' declarations about student loans, for example, and student fees. That would be childish, except I just mentioned it. Oops. So presumably won't go ahead. The Conservatives, obviously, if the Conservative Party wins, clearly they will go ahead. If they're in coalition with the Liberal Democrats, they may not, because the Liberal Democrats will try to oppose it. If they're in coalition with another party that potentially they might be in coalition with, like UKIP, for example, then no doubt it will go ahead full bore and might even be extended in some complex way to other EU citizens as well, if they can possibly find a way to do so. But that will be a matter to see. Now, the bit I'm most concerned about is unlawful discrimination. Nothing in the Immigration Act gives you a blanket license to discriminate unlawfully. Okay, so it is clearly unlawful to discriminate on the basis of race, colour or creed without good reason. Now, the Immigration Act gives some reason in a specific category of situations, but it is not a blanket right for landlords to say, no, I don't want people who aren't British, for example. You can't do that. Okay, so it would be unlawful to apply the checks in a discriminatory way. Everyone should be checked. You can't apply the checks only to people who aren't white enough, for example, or who sound a bit funny. Okay, so looking or sounding foreign is not a reason to check people. Looking and sounding British is not a reason not to check people. Everyone needs to be checked. That's probably a really important point to get across to busy staff in offices who might say, oh, well, they were British, I didn't bother checking, because that's a really obvious thing for them to do, but it's unlawful. You cannot apply less preferential terms for people who should be checked, which I think is extreme, or at least the government's guidance is that you can't do that. So if you have a time-limited right to rent for 12 months, I can't say to you, well, I would have given you an 18-month tenancy, but because you have a time-limited right to rent for 12 months, I'm only giving you a 12-month tenancy. That would be unlawful discrimination on the government's current view of their code of practice. I'm not 100% sure I agree with that, and there is a way around it, but that is the government's opinion. Okay? So the general principle must be that the basic check is carried out on everyone for the right to rent, but it should not then be used for any other decision-making purpose. So really, ideally, from an agency point of view, you probably want to carry out a right to rent check and then simply say to the landlord, we are satisfied they have a right to rent for at least the next 12 months. But we don't really consider it appropriate to discuss with you their nationality or any limitations on that right to rent. Otherwise, you're just inviting someone to make a decision that is unlawful. Okay? Obviously, practical stuff, I think there needs to be massive clarity to both staff, landlords, and tenants why this is being done. I would strongly advise people put a notification on the front of their terms of business that's very clear with landlords what you will and won't do and why, and what they can and can't do and why. And I think there needs to be much more clarity for tenants. I think there's going to be a major problem because the government's completely failed to bother telling tenants. I think there's a real possibility if you say to all tenants, I want to see your passport and all this documentation, they're going to start saying something about the Data Protection Act or unlawful discrimination. You need to be very clear that all prospective tenants are being checked and there is a reason for it, and you need to be clear why that reason is. And I think front office staff are almost certainly going to be quite carefully briefed to answer core questions politely but firmly. Otherwise, there's going to be all kinds of trouble. In principle, the Home Office is in fact supposed to tell people as they enter the country about this stuff, but we'll see, is all I can say. The Home Office does indicate in their guidance that as people enter the country and get visas and stuff, they'll be given a leaflet. I don't assume that Home Office officers on border will sit there and say, we just need to let you know that you may not have a right to rent in the UK. I can't really see them saying that, so I presume a leaflet is going to be produced and given out, but I wouldn't rely on it. I wouldn't rely on people reading it, or even understanding it, of course, either. There also needs to be very clear statements to what the data should be used for. Obviously, the Data Protection Act is not wavered by the existence of the Immigration Act. It is wavered to the extent that you require this data for an Immigration Act check. It is not wavered in a general sense, and therefore you can't cross-deck data for Immigration Act checks for other purposes without telling people. Just as you can't cross-deck people's data for marketing purposes without telling them. You need to be very clear what the data is for and what it's going to be used for. You really need a very clear process. My general position is a process in outline will be to ask their nationality, ask for a basic form of identification to confirm that nationality, and that might be the way you stop. If they say, I'm Norwegian, can I see some ID, please? Here's my Norwegian passport, I just need to photocopy it, that's fine. Boom, job done. You tell the landlord they've got a right to rent. End of discussion. Okay? If they don't meet that test, then you need to say, well, we need to establish whether you've got a right to rent. Can you give us some evidence that you have a right to reside in the UK, either on a permanent basis or on a time-limited basis? And then confirm. Again, if they've confirmed all of that, that's where you stop. And ideally, you shouldn't be passing that data on to the actual renting decision. And I suppose in the ultimate ideal, if I had a big enough office, I would try and separate the two functions. So I wouldn't have my negotiators doing this bit. I'd have someone else doing it, and not pass all the data back to the negotiators, and simply say to them, this person has a right to rent, so that there could be no suggestion that the actual decision was being made based on right to rent data. Enforcement. It is in no way a criminal offence to fail to check. It's not a crime. The enforcement is by way of a civil fine. So you don't get a criminal record. The fine does go up for repeated offences, but the criminal record is not passed over to other stuff. So if you are done for a right to rent, that doesn't mean, for example, you can't become a judge or a solicitor or a police officer or anything else like that. All those things that you are a Boy Scout leader, all those things you always wanted to do. Okay? Really, it shouldn't affect other issues, but I think that remains to be seen how that's going to be worked out. I'm a bit worried how some local authorities will treat this for selective licensing. In principle, I don't think that they can consider this for selective licensing, but given that some local authorities who have introduced selective licensing schemes in London are in part doing so in tandem with the Home Office, I am concerned about whether this data is going to end up being passed across, and then someone's going to be told, no, you can't have a selective license to be a landlord because we've discovered that you didn't bother checking right to rent in the last year. So I'm a bit concerned about that. Again, I couldn't possibly comment as to why this isn't a criminal offence, except kind of obviously the government didn't want a court to get their hands on it, because the court might take a sort of different view about this stuff. Right, it is enforced by the Home Office, not by local authorities. Lots of people seem to be under the impression local authorities are doing this work. They're not. Okay? Local authorities are involved only to the extent that specific areas of local authority responsibility are being used to set boundaries. The local authorities don't do the enforcement. It's done by the Home Office. I suspect this probably means that there's going to be quite limited enforcement in most cases, and actually the enforcement will be when there is an immigration raid and they pick people up, they then turn around and say, oh, you're a landlord of this property, so we're fining you because you didn't do the checks. So it's more, in most cases, I expect it will be an added on top. And then, of course, there'll be, hopefully, a flow of information, in theory, from people who are reporting to the Home Office to get people picked up. So I think there'll be quite limited enforcement. Enforcement works by initial intention notice being served by the Home Office, which perversely they can do without checking your liability in any way. So they can just say, oh, we arrested someone at this property who didn't have immigration status, so we've decided that you didn't bother doing the checks. Here's an enforcement notice, please pay. Which seems a little unfair, but there we are, that's how it works. And it's actually stated in the Act that the Home Office is under no obligation whatsoever to check your liability before issuing a liability notice. You then have 28 days to object. If you don't object within the 28 days, then you have to pay it, even if you weren't actually liable to pay it. But that's the way the law's built. If you object within 28 days to the person who actually issued you the fine in the first place, they then will serve you with a response to your objection notice, either reducing the fine level or saying, nah, pay us. And you then have a further 28 days to appeal to a county court. Basically, you can only appeal on the basis the fine is too high or that you're not liable. There aren't any other grounds for appeal, like it's not fair or anything like that, so that's not an option, I'm afraid. You can ask for payment by instalments, and the Home Office will allow that. They're also now apparently going to offer a 30% reduction if you pay within 21 days. So rather like local authorities do with parking and speeding fines, and they say if you pay promptly, we'll chop a bit off, the Home Office is going to do exactly the same thing. Now clearly, that's going to mean for many people that they won't bother contesting certain areas of liability because they'll just take the lower fine and not bother running the risk. I have no comment on that method of enforcement. Right, currently the penalty sum is divided up very simply. Not entirely happy with the way this has been done. It's divided up into first and subsequent breaches. When I say subsequent, I mean subsequent within 3 years. So basically the clock, once you get hit with a single fine, you've got 3 years. If you're hit again within 3 years, the fine goes up. If you're hit after 3 years for a second go, you get the first level fine again. And there's a separation between lodgers and private rented accommodation. So basically, if it's your first offence, 80 quid if it was a lodger, £1,000 if it was private accommodation. If it's a subsequent breach for lodgers, 500, and then the full 3,000, which is the maximum if it's rented accommodation. There doesn't appear to be any plan at the moment to have any greater gradation than that. That wasn't quite what the Act set out, but there we are, that's what the Code of Practice currently is. It may, of course, be amended to have greater gradation in the fine structure, especially if the court tells them that they have to. So to finish off, some practical stuff. Agency terms of business. There needs to be maximum clarity in agency terms of business as to who's actually doing these right to rent checks. There's no obligation on agents to assume this responsibility if they do not wish to, but you of course need to be crystal in your terms of business who is assuming that responsibility. We ain't doing it, it's your problem. Yes, we're doing it, and this is what we'll do. There obviously needs to be some protection for the agent. I would certainly include an indemnity saying if you're doing it and you don't do it and we get fined, then one, we're entitled to tell the Home Office it was nothing to do with us, and two, we expect you to pay our fine. And obviously there needs to be some clarity about non-discrimination policies. Most agents have a non-discrimination policy in their terms of business. That's going to have to be tweaked slightly and rewritten and say, probably along the lines of saying, we won't pass you full right to rent data if we're doing the check. And if you ask for it, we'll assume that you're trying to discriminate and we reserve the right to terminate our instruction or something like that. Tenancy agreements. One of the things that really bothers me about this is subletting. Obviously, the real problem with this is this position where the Home Office is entitled to say, well, you let to two people, but there was a third person in there who didn't have a right to rent. We believe that you actually knew about that all along, so we're fining you. So I think tenancy agreements need uber clear subletting statements. I've been saying this for a long time about HMOs. I tend to find that most letting agents' tenancy agreements are still a bit weak on subletting. They sometimes say you can't do it. They sometimes say, oh, only permitted occupiers, but then often that's not backed up by very, very clear positions from negotiators and property managers. So there needs to be very clear statements in the agreement about subletting, and it needs to be backed up aggressively at all times by negotiators and managers. If a negotiator makes some casual email statement saying, oh, well, of course you can have other people there as long as we don't really know about it, that's not going to go down very well. And that happens quite a lot. I see plenty of emails of words to that effect. Okay? Obviously, very clear statement about other adult occupiers. You don't really care about children, so you might just want to have a very clear statement saying you can't have any other adult occupiers without very clear written permission. I would be inclined to put it in as a condition to all tenancy agreements that the tenancy agreement is conditional that all adults maintain a right to rent at all times, for two reasons. First, it deals with a situation where the tenancy is signed pre-occupation, but you don't have the opportunity to do the checks until they come into the country. Because if it's a condition, precedent of an agreement, then if they don't satisfy the right to rent check, you don't in fact have a contract, and therefore you don't have a tenancy, and therefore you can refuse access to the property, which would be a logical way to deal with it. And also it would allow eviction where the right has evaporated. Clearly, you're not obliged to evict, but I'm not really going to want someone in my property who at some point is going to be arrested by the Home Office and carted off. It's not a really very satisfactory position for a landlord. They're probably going to prefer to achieve certainty by simply proceeding to eviction if they can. And that obviously deals, again, with this difficulty that you can't discriminate by giving shorter tenancies to people with time-limited right to rent. But if you put in a clause that says you must maintain a right to rent at all times, then at least you do have the cover of saying, well, if your right to rent is evaporated, we can take steps to evict you. Which is not discriminatory. That's reasonable. Obviously, you need to think about procedures, very important. Obviously, information to applicants. How are you going to tell them? When are you going to tell them? Are you going to make consistent statements? When are you going to do these checks? Earlier the better, hint. I'm like referencing time, or as soon as possible. You need to think about charging. Bear in mind, of course, the cap guidance for charging, for referencing. Are you going to change your charging structure for right to rent checks? If it's going to cost you time and money to do it, then you're required to advertise that alongside the rent from the start, otherwise it would be unfair trading. You need to be very clear with your staff about discrimination. There's going to have to be real caution. It'd be very easy for staff to get themselves into a terrible mix-up with right to rent and start accidentally implying to people they're not renting to them because they're from X country. That would be most unfortunate. Obviously, you need to think about how you're going to record people's status. and record not only whether they have a permanent or time-limited right to rent, but also allow a time-limited right to rent to be upgraded to permanent, and also consider when a time-limited right to rent is going to be expired and how it's going to be renewed, and therefore have a mechanism to keep moving the expiry date onward. Okay, and of course you're going to have to find a way of scheduling those follow-ups prior to the actual expiry date of a time-limited right to rent, so that you actually have got everything done before the expiry has occurred, and if necessary reported to the Home Office. So there are quite a few procedural steps which are non-trivial because they require changes to systems. So although this isn't happening right now for a lot of people, given the time needed to put in place systems changes, this is probably the time to be thinking about it.